So thank you everyone for joining us today. This is our October sidebar. We wish we could be holding these in person in our office, but with the current events, we are going to do this virtually through at least the end of the year. Hopefully, I think we'll be seeing a couple of you at our blood drive tomorrow, and we're looking to do a few of those in the future too. So just keep looking for all of our events and the monthly newsletters and the weekly e-briefs. But for today, we have Judge Lucero, the Presiding Disciplinary Judge, here to present an excellent CLE. So we're going to hand that off to him, get it started. For those of you who have attended our prior CLEs, you are currently muted. The way to ask any questions in real time, if you have them, is to use the chat function at the bottom of the Zoom window. One of Judge Lucero's clerks will be monitoring the questions, and he will moderate those questions at the end of the session. But if there's anything you do have a question about that you feel you'd like to return to or just hasn't been covered, please use that chat function to ask a question, and then the judge will respond to those at the end during the Q&A session. But otherwise, I will turn it over to Judge Lucero. Thank you for joining us, sir.
Thank you, Kyle. It's a pleasure to have an opportunity to speak to the Boulder Bar. Today, what I'd like to do is present for you a bird's eye view, so to speak, of the Presiding Disciplinary Judge's court and how it operates. Before I get into that, I want to just discuss briefly the system that we have in general, not just our court, but the entire system that involves lawyer regulation. First thing is, the system that we have today is unique in many ways, and we're only one of 3 states. We're the first state that has a system like ours with a presiding disciplinary judge, a paid prosecutor with an office, much the same size as I understand it as a Boulder DA's office, and to handle regulatory or disciplinary matters in terms of our court. The system was designed to take care of some of the problems that were perceived with our system that we had previously. I can tell you a little bit about that because I was on the Grievance committee. That's the system that we had back in the 80s. And 2 of the problems that were pretty frequent were delays in the proceedings, and then the second was inconsistent results. So what this system is all about, when you look at the big picture, is trying to resolve those cases that are not a danger to the public or perceived as a danger, that those cases where lawyers are involved and are not perceived to be a danger to the public, and to resolve them in ways short of coming to our court. There are a number of committees, and there are different arms of the attorney regulation system that take care of matters before they ever get to a formal hearing in our court. And let me just give you a quick example. There are a number of committees that spend an awful lot of time on the rules in order to make them as clear as possible. I know there are nuances in those rules, and sometimes you look at them and you scratch your head and you wonder, what does that really mean? Well, those folks work very hard on trying to get answers to those questions and draft rules that are clear and understandable. The other thing that the process that the court has, the Supreme Court has developed, is COLAP. This is a separate and independent office that helps lawyers who have problems. And it could be mental problems, it could be physical problems, it could be financial problems, but the whole idea is to help a lawyer before the problem gets so bad that it affects their practice. The other is CAMP, and this is a mentoring program. And that mentoring program is again designed to help lawyers stay out of trouble and to be good, more than that, to become good professional lawyers. And then finally, there's the whole process of having a case go through the attorney Office of Attorney Regulation. And that process, you will see, is one that is designed to separate the wheat from the chaff. Those of you who have been prosecutors know I had a boss, Dale Tooley, in Denver. I was previously a prosecutor. And he told us, you can't dance every dance. And that's really true. One of the most important things for that office is to try to resolve cases without them going to a formal proceeding. And they've got a lot of tools that allow them to do that, including a diversion program. So the final step, if none of that works, is there could be a formal proceeding. And let's go ahead and talk about that. First slide, please. There are three misconceptions that folks have about our office, and one of them I encountered a lot when I first started. I don't encounter it as much nowadays, but this is one of the reasons I get out and talk to lawyers. I've had folks come up to me who are lawyers, who know about our system, who think that I work for the Office of Attorney Regulation. That would be much like your district attorney in Boulder being the boss or supervising your judges. That would present a serious problem, a due process problem. That's not the way it is. Quite the contrary, our system is set up much. There's a lot of parallels to a criminal and a civil case. I'll talk about it in a little bit about the courts describe our system as a sui generis system of justice. It's unique, but one of the most important foundational principles that our system works is based upon is that our office needs to be and is independent, just like any other judge. Independent from the Office of Attorney Regulation, independent from the lawyers who practice before the court. And that's a very important thing in our court. Next slide, please. The second misconception is something that I think some members of the public have, and that is that our regulation system is really designed to protect lawyers. And let's face it, we're the only profession in our state that's self-regulated. And when you have a citizen who sees that, if they walked into one of our proceedings, they would see three judges likely on the bench. This would be the hearing board panel that would hear a case. There would be lawyers representing both sides. And the court staff, two of them would be lawyers. The witness is not a lawyer. The court reporter is not a lawyer, but everyone in the courtroom is a lawyer. And this misconception, I think, comes from the fact that there's a lot of distrust of the legal profession. The truth is that this system is designed to protect the public, not lawyers. Now, there's a flip side to that, or another aspect to that, and that is lawyers have a right to due process in these proceedings, and they need to be fair. But the Supreme Court has made it very clear from the very beginning that the whole purpose of this program is to make sure that lawyers who are unable or likely to be unable to meet their professional responsibilities are subject to sanctions or disability proceedings. Next slide, please. This misconception I still encounter, and I'll tell you how it comes about. It's, oh my God, the Office of Attorney Regulation has decided that I have done something wrong. This is a lawyer saying this. And so what I've seen over the last 15 years are lawyers who fail to participate in the proceedings. They may get a letter from the Office of Attorney Regulation asking them to respond to a complaint that a client or a judge or someone else has made, and they literally put the letter in the bottom drawer and don't ever open it. And a lot of this comes from a mentality that it's useless. They've already decided that I have done something wrong. And I will also tell you that some of this comes as a result of serious issues with mental health, primarily depression. It could be a disability based on drugs or alcohol as well. The truth is, if a lawyer is competently represented, there are many procedures, not the least of which is the burden of proof on the prosecutor, that need to be fulfilled before a lawyer can be sanctioned in any way. So a call from the Regulation Council doesn't mean the end of the world. It's important that the lawyer recognize that it needs to be addressed and not stick their heads in the sand. That happens, frankly, more often than not with sole practitioners who find themselves overwhelmed. And it doesn't surprise me. I've had lawyers that come in that are respondents, responding to a complaint, and they're sitting there at counsel table, and I ask them if they have an attorney. The answer is typically no. And the reason for that, as it's explained to me, is that they don't have the money. There's some good news on this front. The Ethics Committee of the Colorado Bar Association is now gearing up to represent respondent lawyers who are representing themselves, and they'll be doing some pro bono work in that area. And any of you who have ever tried a case against someone who's not a lawyer, you know how difficult that can be. And respondents who are lawyers and know the law in their particular area, they're at a disadvantage in these proceedings in our court, because there's a whole new set of rules. There's a whole set of sanctions and the way sanctions are meted out, and the substantive area that have to be learned. Many of these lawyers are sole practitioners that are trying to continue practicing while they are trying to defend the case, and that's very difficult. Next slide, please. All right, so I want to give you an overview of our system and how it works. First of all, I am appointed, the presiding disciplinary judge is appointed by the Supreme Court. I'm not a quote unquote constitutional judge appointed by the governor. So I am vetted by the Supreme Court. They are, in essence, they're my supervisors. But again, we have independence. I don't have a call. I don't get calls from the chief or any of the other Supreme Court justices telling me, you know, here's what you ought to do, or here's what you can do, or whatever. I have a liaison, 2 liaison justices that I work with, but there's never any discussion about cases. There are discussions from time to time about broad policies, but our court is independent. I am nevertheless appointed by the Supreme Court. So what kind of cases do we hear? All of you are, I'm sure, familiar with the discipline cases that go through our court. There's a section to the Colorado Lawyer that gives every month a summary of the cases that we have. And that's certainly a part of what we do. But we also do reinstatements and readmissions. Those are cases where lawyers have been either disbarred or suspended and seek to come back and practice. Yes, you can come back after being disbarred. It's not easy. And yes, you can come back to and be practicing again after you've been suspended. Again, it's not easy. I will talk about that a little bit later. So those cases are some of the cases that we handle. Attorney disability is another issue. that we handle, another area of, and I keep hearing that we will start having more and more of those cases as the lawyer population grows older. I haven't seen it yet, not the way it's been predicted the last 5 to 10 years, but we all know, I know, I'm a baby boomer. There are a lot of my peers who have already retired or are planning on retiring and are at the end of their careers. The other area that we handle is unauthorized practice of law and contempt that comes with that from time to time. These are folks that practice law without a license, and you'd be surprised how many situations arise there. Those can be some of our most interesting cases. And finally, we handle character and fitness cases. If an applicant to the bar has passed the bar and then is interviewed by the Character and Fitness Committee and they make a determination that the lawyer or that the lawyer to be is not fit to practice, that applicant can file a petition in our court and receive a hearing de novo. We're not bound by the findings of the Character and Fitness Committee, but we hear the case with a 3-judge panel. Next slide, please. Always look at the date for this quote. We've been trying for a long time to be free from suspicion and, an honored profession. And this is certainly what we strive for. And the Supreme Court, in adopting Rule 251, says that this is why they're doing it, the rules of procedure that apply to disciplinary proceedings. That is to have the highest standards of practice for lawyers who are, by the Supreme Court's proclamation that they have a license, the court is saying all these the lawyers that we say are licensed here in Colorado, we're in essence saying they're the kind of lawyer you can rely on, the kind of lawyer that you can put your most serious matters in their hands and understand that they will be professional and handle those situations well. Next slide, please. So let's talk about disciplinary proceedings. Those are the ones that you read at the back of, or the summaries in Colorado Lawyer. Our system really is what the court calls sui generis. It's unique. It's really a blend of civil law and criminal law. I often say it's a little bit country and a little bit rock and roll. It's that way because we have rules of procedure that all of you who practice civil law will be very familiar with. Rule 251 almost completely tracks the rules of civil procedure. Not in every instance. There are some instances where there are differences. But we use 251, which is designed for disciplinary proceedings. And if an answer is not available through 251, we looked at the rules of civil procedure for guidance. At the same time, we look at substantive law that the Supreme Court has issued over the years. They have told us, and certainly the case, that the only entity, the only forum in the state of Colorado that can make the law on lawyer discipline cases is the Supreme Court. So their case law is really one of the sources for our decisions, as are the rules themselves and how we interpret those rules. We also use something called the ABA standards for imposing lawyer sanctions. This is really one of the most important sources for our decisions. The Supreme Court doesn't use the word Bible, but I think it could be fairly stated that the Supreme Court, these are the rules that they want hearing boards and the presiding disciplinary judge to follow. And these standards are very nuanced. And any of you who practice criminal law will notice when you see how an analysis is done about imposing sanctions, and we'll talk about that in a moment, how it looks an awful lot like what happens in criminal cases. As an example, what was the lawyer's state of mind when the lawyer committed whatever act it was that is alleged? And of course, the higher the level of culpability, the more serious the potential sanction. Next slide, please. So disciplinary proceedings are initiated in a number of ways. The Office of Attorney Regulation, I heard in a CLE that I participated in recently that they have upwards of 3,500 cases last year. And they receive those complaints from clients of the lawyer. They can receive it from a judge that the lawyer appears before. They can receive them from opposing counsel. And from time to time, they might, based on what I've seen, they might initiate an investigation themselves based upon something they read in the newspaper that might not have been reported. So what I want to tell you about that process when the Office of Attorney Regulation investigates is that their less serious matters are diverted. And in one way or another, there's a diversion program, but there are a number of other steps they can take to resolve a case if it's a less serious case. And sometimes it requires that the lawyer go to ethics school. Or it might be a lawyer has an alcohol or a drug problem and they might be put on a program. But there's a lot of discretion given to the Office of Attorney Regulation on how they can handle these cases. So if the system is working the way it should, those less serious cases are resolved without a formal hearing. The more serious cases go to something that used to be called the Attorney Regulation Committee, and I think it's got a new name now because it's incorporated not only lawyer discipline, but I think unauthorized practice of law as well. But the more serious matters go to this committee, and these are folks that are appointed by the Supreme Court. They look at these cases much like a grand jury, and they determine or try to make a determination whether or not there's reasonable cause to believe that the attorney has violated the rule. If they do, then the Office of Attorney Regulation is authorized to bring a formal complaint in a court. Next slide, please. So one of the ways that matters come to our court is by immediate suspension. This is a temporary suspension pending a formal complaint, and it's not used very often. It's a very specific rule, and it was designed to immediately address problems where there are serious and substantial harm being done to the public. For instance, like a crime has been committed or a conversion of money from a client. Those might implicate this immediate suspension. And historically, I told you that I was on the Grievance Committee years ago, and in those days, a case had to be resolved all the way through the Supreme Court before any kind of discipline could be imposed against the lawyer. In many instances, that meant 2-3 years down the line. And in the meantime, the lawyer would keep their license, and if they were causing great harm to the public, they would, in many instances, continue to do it. This is a rule designed to address those serious problems immediately. One of the things that is very important about this is that the lawyer has a right to a hearing in a full hearing within a very short period of time. So it's not used very often, but it is there in case it is a case that needs to be resolved in the interest of protecting the public from serious injury and immediate and substantial, substantial harm. The other way the other way matters come before me is a stipulated agreement. That might be something that is before the advisory committee, before a formal complaint is filed in our court, and the parties want to bring an agreement to me. I review those. Many times, like in civil and criminal cases, most cases are resolved even though they've been formally filed. And the important thing to know here is that when I review those stipulations, I look at them in terms of what is the case law in this area that the Supreme Court has established? What do the ABA standards say that the appropriate sanctions should be? And part of what I do is to make sure that there's some proportionality and consistency in the way those cases are resolved, even if the parties say we have an agreement. Next slide, please. So the other way that matters come before our court is a formal complaint. And this is after the Office of Attorney Regulation has done their due diligence and they have determined that they have a case that they think they can prove by clear and convincing evidence. The number of complaints that come to our court every year can range, but it's anywhere from 120 to 140 cases a year. Next slide, please. Let's talk a little bit about pre-hearing procedures. We have, just like in civil, there's a complaint and an answer. The answer has to be, the complaint has to be answered in 21 days. Once that is done, the parties are allowed to call our administrator and set a hearing date. And we will also establish, along with a hearing date, it becomes part of a scheduling order that we provide to the parties. And this scheduling order is very detailed. Amongst the matters that are addressed in that scheduling order are motions, deadlines for motions, deadlines for discovery, deadlines for a settlement, 21 days or 28 days before the hearing. A settlement must be provided. In addition to a number of procedural issues, there is a portion that requires the lawyers, the parties, to provide pre-hearing materials so that a hearing board can see what is the law that you're relying on. What is your legal theory of the case? What are the facts that you think are beyond dispute? And what do you think the appropriate sanction should be, if any? And which ABA standard are you relying on, or standards? If an answer is filed, then discovery and motions practice ensues. And by the way, when I first started as a presiding disciplinary judge, there were few motions for summary judgment and judgment on the pleadings and substantive motions like that, dispositive motions like that. That has changed. There are an awful lot of motions filed. So there's a real active motions practice in our court. And like in civil procedure, if the respondent doesn't file an answer, then there's a default. And this is tragic. This happens an awful lot with those lawyers who are pro se. They don't file an answer. And then the only issue that's remaining is what is the appropriate sanction in the case. And depending on what the complaint states, It can be very, the game could be over. Let me put it that way. If there is a charge, for instance, that's well pled, a claim that says that the lawyer converted money and did so knowingly, and there's no answer, well, yes, there's a sanctions hearing, and the lawyer has a chance to argue that there's some mitigation in that process. But presumptively, under the case law, if you convert money, if a lawyer converts money from a client or third person, the presumptive sanction is disbarment. And any mitigating factors, the burden is upon the respondent to show those. So it's, unfortunately, we see a lot of defaults. Next slide, please. I want to talk briefly about the hearing boards that hear these cases. I am the presiding disciplinary judge, and I sit with 2 other hearing board members. If you ever come to our court and watch one of these proceedings, you'll see what look like 3 judges up on the bench. We all wear robes. The lawyers refer to me and my colleagues who are on the hearing board as Your Honor. And they're judges in that case. These folks are some of the best lawyers in the state. And why do I say that? The Supreme Court and the advisory committee to the Supreme Court vet these folks. When we had our last round of appointments, I contacted each of the presiding judges in all the districts in Colorado, and I asked those judges to give me the names of 2 highly respected, competent, and professional lawyers. And I got names from each of the jurisdictions, and we submitted those names. And for the most part, well, all of them that we submitted were approved by the Supreme Court. The other thing we did when we asked the judges for names of lawyers is to let them know that diversity was an important part of what we were trying to accomplish. So our lawyers are diverse, our hearing board members are diverse in every sense of the word, and they're from across the state. So they represent, in some instances, views about the practice of law that are perhaps unique to their jurisdiction and maybe not so much to the Front Range. But it's very important that we have all lawyers, different parts of the state represented in this process. And of course, it's really important to have citizens in this process. And we are trying very hard to recruit qualified citizens for this process. And the reason is, if the whole purpose of our disciplinary system is to protect the public, we ought to have the public at the table helping make those decisions. These folks, for a particular hearing, are selected at random, and they're subject to motions for disqualification by the parties. That's under Rule 90, 97, 98. And affidavits have to be filed. And I rule on those issues. Very seldom does that happen, that there's a motion for disqualification, but the rules allow it. Primary thing that these hearing boards do is they help me find what the facts are in the case. And once we find out what we all agree on what the facts are, and that is what have the people prove by clear and convincing evidence what they've alleged in their complaint. And that's a process that follows the hearing. And we sit and used to, when we were doing these things in the courtroom, we'd sit and deliberate much like a jury. Next slide, please. So if you walked in on one of our proceedings and you're a lawyer who tries cases, you'll recognize a structure right away. It's much like a civil case, a bench trial, only there are 3 judges. There's the prosecutor is there, and they must prove all rule violations, as I said, by clear and convincing evidence. The attorney who's the respondent in the case sometimes defend themselves, and sometimes they're there with counsel. I rule on all the evidentiary issues and other legal issues that might come up in the matter, including pretrial issues. The hearings are open to the public, and I might add that the regulatory process is as transparent as possible. And the reason for that is we want the public to know how decisions are being made. Now, there are some exceptions. One of them is those disability proceedings that I talked about earlier. Those are not open to the public. Those are confidential. There are ways, if there are confidential matters, that I can rule and issue a protective order if appropriate. But generally speaking, the proceedings are public, and all of the filings that are in the case are open to the public. Next slide, please. The other important thing that a hearing board does is it helps, it deliberates and finds the facts, and then it helps me rule on the, well, all of us do. We vote on what rules have been violated. And if there is a rule violation that's established, then the next important thing is to look at the sanction. What's the appropriate sanction? You know, the ABA standards go all the way from private admonition to disbarment. And there's a whole range there. So the analysis generally is, what was the duty that the lawyer violated? More important, what was the injury caused? Was it physical? Was it emotional? Was it financial? Was it serious? What was and this is a big one, the mental state. What was going on in that lawyer's head? And sometimes that issue can really make a big difference in the case. Obviously, there's a big difference between a lawyer making a mistake and intentionally trying to harm someone. And so the greater the mental state, the greater the injury, the greater the presumptive sanction. Now, let me give you an example of why mental state is so important. There is, as I told you before, there's sort of a black letter law, or we all learn that if you steal from a client or you convert from a client, that's usually going to be disbarment, and that's presumptively true. There was a case that was tried before I became the PDJ, and the hearing board issued an opinion stating that the respondent lawyer should be disbarred, and it was based upon the case law. That was a reasonable decision, determination, because the lawyer had stolen money from clients and her law firm. However, when that case was on appeal, one of the issues that the Supreme Court looked at was, what was the lawyer's mental state when committing these acts? And it was determined at the hearing, without any opposition. A psychiatrist testified that she was suffering from post-traumatic stress syndrome as a result of being raped, and that her conduct was in great measure caused by that mental defect, or by the mental issue that was there. And what they indicated was this: they looked at the case. It's the Lujan case. They looked at it and they said, she did take the money. However, her mental state, and it's not in dispute, it wasn't disputed at the trial court level, was something less than intentional or knowing because of that post-traumatic stress. And they decided that the sanction should be no greater than a year and a day. So this mental state issue is a big one that has to be It's a very important issue in all the decisions. The presumptive sanction can be adjusted up or down because of these aggravating and mitigating factors. And I'll just go through briefly some of the aggravating factors. You can think that the opposite is the mitigating. Is there a prior misconduct? Is there dishonest conduct, or is it selfish? Is there a pattern of misconduct? Are there multiple offenses? Is there bad faith obstruction during the process? Is there submission of false evidence? Is there a refusal to acknowledge the wrongful nature of the conduct? Is there a vulnerable victim? And does the lawyer have substantial experience in the practice? Those are aggravators. They're flip side mitigators. And one of the things that's really important is if the lawyer gets it. That's the way I've heard it described from the Office of Attorney Regulation, and a lawyer who represents respondent and does so very successfully, that it's really important that the lawyer get it, understand that there's a serious issue. When they don't get it, it can be a factor that weighs heavily against a respondent lawyer. So case law is helpful, but not binding. And the Attorney F case, I won't have time to go into it in detail here, but it really describes how important this analysis is under the ABA standards, to the extent that if the hearing board does that analysis, and the Supreme Court understands how they arrived at that analysis, it can be inconsistent with prior Supreme Court decisions. An awful lot of discretion left to the hearing board on that. Hearing board opinions, however, are not stare decisis, and the Supreme Court's made that very clear. Next slide, please. So there are a number of sanctions that can be imposed. Disbarment is the most serious. Stealing from a client, engaging in a scheme to defraud, those are the kinds of cases that can result in disbarment. Of course, serious criminal cases can as well. Cases involving fraud, especially fraud on the court, submitting false documents to a court or signatures. The other sanction that can be imposed is a suspension. And there is a wide range of sanctions within that category. A suspension can be fully served for up to 3 years, or a portion of it can be served, or a portion of it can be served, and the rest of it on probation. But suspension is really probably where most of the cases that we hear end up in terms of a sanction. Public censure, that's exactly what it says. There's an opinion that's made public, and it describes in detail what the facts are in the case. Then there's a private admonition. Diversion is available, but it probably shouldn't even be here on this slide because diversion isn't considered discipline. Diversion is an awful lot like a deferred judgment. If the lawyer abides by all the provisions of the diversion, the case is dismissed usually after a year, and it's as if the case never was filed in the first place. Next slide, please. Appeals go directly to the Supreme Court, and there's both sides have a right to appeal directly to the Supreme Court. There's a possibility for a stay pending an appeal. At this time, our rule requires a hearing board to look at, in the first instance, whether a stay pending appeal is appropriate. And essentially, the rule requires a hearing board to grant a stay unless there are no conditions of probation or supervision that would protect the public in the interim. The Supreme Court often issues an order, a ruling on hearing board opinions that is a paragraph, less than a paragraph long, and the applicable language is something like the hearing board's opinion is affirmed. And that's not very helpful for helping hearing boards on future cases in deciding how the court is thinking. But if they want to, and sometimes they do on unique issues that come up, the Supreme Court will write a full opinion. And frankly, I like to see that because I know exactly what they're thinking, and we're able to conduct our proceedings in accordance with that. And ABA standards, of course. Next slide, please. So our system really is designed to help those that can be rehabilitated. And you'll see that in the provisions for reinstatement and readmission. Next slide, please. So reinstatement is offered to any lawyer who is suspended for a year or less, and that can happen by simply filing an affidavit and the Office of Attorney Regulation agreeing that the lawyer has abided by all the conditions of probation or whatever it was that resulted in the suspension. But if the suspension is for less than 1 year, that process is by affidavit. If it's for 1 year or more, it's by petition that the lawyer, the respondent lawyer, has to file. And that usually results in a formal hearing before a hearing board. The respondent is responsible for proving, they have the burden of proof by clear and convincing evidence that they have been rehabilitated from whatever the issue was. They're fit to practice, and they're in compliance with all disciplinary orders. And if they're not successful in a reinstatement, then they have to wait another 2 years. And this can be important because if a lawyer's out for 5 years or more, they have to take the bar exam again. Next slide, please. So with readmission, this applies to disbarment. The lawyer is out for 8 years, and the same standards and procedures apply as to reinstatement in a situation where it's 1 year or more. And again, in this instance, they have to pass the bar. I have seen some of the best days in my court, in my estimation, are some of the lawyers who have come back and have been, they come back into the fold and they're accepted because they really have put their life back together. Mr. Fritchie was one example that was remarkable, and I'll never forget his case that he came back after being suspended for more than 8 years, disbarred for more than 8 years. And he had a serious cocaine problem, and he addressed it and did so well in presenting his own case. Here's an exception to the rule about representing yourself. He did a marvelous job. He did such a good job before his petition ever got to our court that the Office of Attorney Regulation, the rules required that we have a hearing, but they essentially came into court and said, we agree with him. He should be readmitted, I'm sorry. Next slide, please. I will tell you that we're in a situation now where there are a lot of, like I said a little earlier, a lot of lawyers who are baby boomers and are seeing the end of their career. And I just looked at a statistic today, and this is an old statistic. I think it was back from 2006, that lawyers over 55 then comprise more than 35% of the bar. It's got to be much more than that today. So we're dealing with an aging population of lawyers. and all of the issues that result from that. Next slide, please. So disability proceedings, first thing is, they're confidential. This is not something like the rest of the system where it's transparent and it's open to the public. Disability can be something that's physical, mental, or emotional, an infirmity, including addiction. Usually when that issue is raised, and either party can raise it, or in some instances I potentially could raise it based on the respondent's conduct. But when the issue arises, the first thing that I do is order an IME, an independent medical examination, by a qualified psychiatrist or psychologist, or if it's a medical issue, a doctor, and that doctor issues that report. It goes to the court, it goes to both parties, and sometimes we have to litigate that issue. But if an attorney is unable to represent clients, and that can be established, then they are put on disability. Now, the unique thing about that provision under disability is that their substantive case, if there is one, that continues. So they can be tried on the substantive charge of a neglect of a client, let's say, for example, or failing to put money into a trust account. That case goes forward at the same time that the disability proceeding goes forward. Now, there is an exception to that if the lawyer, the respondent lawyer, is incapable of representing himself or herself or assisting counsel in the proceedings. In that case, all the proceedings are stayed until that issue is resolved. As I said, all these matters would be confidential. Next slide, please. All right, the next thing I wanted to talk about is unauthorized practice of law. Next slide, please. So we handle unauthorized practice of law, and this is when someone who's not a lawyer is engaging in the practice of law. And the Office of Attorney Regulation brings a petition, and usually those go to the Supreme Court first, and the court typically appoints our court as a hearing master, and we have a hearing and we prepare a report and give our findings to the court. Those are there's a specific set of rules for unauthorized practice of law, and the rules of civil procedure apply. The burden's on the people to prove by preponderance of the evidence, and there are sanctions to the extent that there's an injunction that can be imposed against the person, and fine for each, anywhere from $250 to $1,000 for each instance of unauthorized practice. These are some of the most, as I said earlier, some of the most interesting cases that we have. The Zot Torres case was a member of the Republic of Colorado, and she was the advocate counsel for them. And she ended up in our court charged with a petition indicating that she was practicing law without a license. One of the members of the Republic of Colorado was in federal court and was represented by a public defender charged with a tax law felony. And the public defender negotiated with the U.S. attorney, and they resolved the case with a plea bargain, which was favorable to this defendant. However, when Zot Torres and the rest of the Republic of Colorado found out that this member had acknowledged the authority of the United States government, she filed a motion on behalf of the Republic of Colorado to withdraw the defendant's plea. It didn't take long for the federal court to figure out she wasn't a lawyer, and the case was sent to our court to determine whether she practiced law without a license. an interesting little fact in that case, when she came into our court, she held me in contempt and then promptly held Justice Bender in contempt. Interesting cases. Next slide, please. The contempt proceedings are under Rule 107. The burden changes when we go from an injunction and the unauthorized practice of law to imprisoning someone, and they can be imprisoned under Rule 107. The rule then requires the people to prove the case beyond a reasonable doubt. There are a number of procedural safeguards that kick in. That this looks an awful lot like a criminal case. If the case is tried, the responding person has a right to a lawyer if they can't afford one. There's a jury. It's a much more complicated case than a typical unauthorized practice of law, where the people are not asking for 6 months or more imprisonment. Next slide, please. Character and fitness, we've had probably about 5 of these cases since the rule changed in 2014. And a number of these cases have come to us where the applicant who has passed the bar doesn't feel that they have been listened to, or that their case was not properly heard. They have a right to a hearing in our court, and we have to determine whether or not they're unqualified to practice law. And these are some difficult cases. What I often say when I go to law schools and talk to the law students is, one of the things that always perks the ears up of a prosecutor is when someone doesn't tell the whole story. And some of these cases are of that nature, where a young person is applying to the bar and there's a question about, have you ever been arrested, or have the police ever detained you? And if they don't put the information down, even though it might, 10 years later, it might not be significant, that sometimes, being honest is a very, one of the principal pillars of our profession, honesty and integrity. So we hear those cases, and we review challenges to preliminary determination that the applicant is not qualified to practice law. Next slide, please. I hope that in this presentation that there are 3 things at least that you gathered from it generally. And one is really important, is that this court, the Presiding Disciplinary Court, is an independent court, and that independence is foundational in the way we operate. The other is that the public the court has made it very clear that the purpose of this whole process is to make sure the public is protected. And protected from what? Lawyers who are unable or likely to be unable to fulfill their duties and responsibilities as professionals, and can be entrusted. The Supreme Court can entrust them to the public and tell the public these folks are qualified to handle your matters. Well, that's true. The protection of the public is important. The other important part of this process is that it needs to be fair in the broadest sense, and there needs to be due process. And there are rules and procedures, and there are case law. There's case law. There's due process. I am not going to tell you it's the same as due process in a criminal case. It's very different. It took me a while to get used to that because I was a prosecutor most of my career. But there is due process. And when lawyers are adequately represented, issues that are important in those cases are, is the lawyer committing this act intentionally? Are they doing it knowingly? Did they make a mistake? And a lot of the due process that comes forth in these hearings is in the hearing itself, and having the respondent lawyer and or his lawyer representing him have an opportunity to explain the lawyer side of it to a hearing board that's fair and impartial. And that's the end of my presentation, and I'll be glad to try to answer your questions.
Yep, and Judge Lucero, it doesn't appear that we have any questions in the chat room. Didn't know if anybody wanted to put forth any questions via video or through chat, but if so, feel free to ask.
Thank you, Ms. Hammer.
Judge Lucero, I have a question.
Oh my goodness, it's Stan Garnett.
I know. And I'm recovering from surgery, so I'm sitting in bed, and hopefully I don't look too disheveled.
No.
But excellent presentation. We really appreciate it. Can you give me a sense? I've always wondered, what is the volume? All of us that have been in public sector work now and then deal all the time with the volume of cases. How many felonies? How many misdemeanors? What do we do? How do we staff them? What's the volume of cases that your court handles in an average year?
Well, it varies, but anywhere from 100 to 170 formal filings in a year. Now, there are, and those are formal disciplinary cases, but there are also, as I indicated earlier, there's unauthorized practice, there's reinstatements and readmissions, there's disability, there's immediate suspensions. We're not as busy as a county court in Denver. I can remember,
Sure.
You could carry your docket under your arm to court in those days. That's not, and nowadays I see those lawyers, when I was going downtown before this pandemic, they don't do that anymore. They have it all on computer.
Right.
We don't have that volume. We have much less, but if the system is working right, each one of those cases that are filed should have been a serious matter. And there's a lot of litigation that goes on with each of them.
And do you know, Your Honor, whether the Colorado volume of disciplinary cases, how does that compare per capita to what other states deal with? Do you have any sense of that? Do guys like you talk to the judges in different states about that kind of thing?
I have a fellow presiding disciplinary judge in Arizona, Bill O'Neill, and we do talk from time to time. It seems to me, although I haven't got a specific number, it seems to me that they file a lot more cases there than they do here. And a lot of that has to do with the culture of the office. I mean, our system was set up, and I think it's working this way so far, to use a lot of discretion, and where appropriate, find a path for a lawyer to have a remedy that's short of a formal hearing. These formal hearings, it's like any other litigation, is very expensive. Especially if you have to get into experts, it's very expensive. So if there's an off-ramp at some point that allows for protection of the public, they're doing everything they can in the Office of Attorney Regulation to resolve the cases that way. I hope you're better.
Oh, I'm doing fine. It's my legs, so I have to be careful how I walk. I've had a couple of surgeries, so yeah.
Was it knee surgery?
No, I ruptured my quadricep tendon back in June, and that's a hard thing to fix, particularly in an old guy like me. So.
Dan and I worked in the DA's office in Denver years ago, and he's calling himself old. I was Those days I was I was a supervisor in those days.
You were a chief deputy in those days. Yep, that's right.
And if you'd have stayed there, you would have been the chief deputy.
Yeah, well, yeah. All right.
Judge Lucero, I have a question from John, who would like you to describe some of the problems with cold tap accounts as far as what lands people in the court.
Oh, that's a good question, because that's one of the major areas of, that's one of the quickest places for a lawyer to get into trouble. And we see an awful lot of those cases. And I've heard, now Nancy Cohen used to be with the Office of Attorney Regulation. Now she's representing respondents and doing a heck of a job. But I remember her at a meeting that we had with the advisory committee, and she would supervise the ethics program for lawyers, that they were required to take as part of probation, et cetera. And she indicated that it was not at all uncommon for lawyers to make comments like, well, when we get that money from the client and we're going to do the work, then it's ours. There's a fundamental, I think there must still be, and this doesn't happen in big or medium-sized firms or firms where there's a lot of collaboration going on, but my sense is it's primarily in sole practitioners who really, it's kind of like, how can I put it? My sense is it's like the old days when we had short check cases in the DA's office. Safeway would come in with, a bundle every week and want criminal cases charged on folks that wrote checks for their groceries, anticipating that the next day they were going to get paid. And then there might be a problem and, the mail didn't come on time or whatever, and their check bounces. I think sometimes lawyers think that it's going to be all right. They're going to have that money there shortly. And what's the problem? I'll go ahead and take it now. But the law is very clear. You do not have a right to that property. Let me back that money, that retainer, until you've earned it. And a lot of that depends on what your retaining agreement is and what it says. Because if you take a retainer and you haven't done any work and you put it in your business account, that's going to, if the Office of Attorney Regulation finds out about that, and the way they do is that account, the trust account goes below zero, or they're required to let the Office of Attorney Regulation know that. And so there are a lot of problems with cold tap accounts. And I think, the most important thing is to understand that money stays in the trust account, the cold tap account, until the lawyer can demonstrate that they earned it per their fee agreement.
And have another question from Damien. Approximately what percentage of the formal disciplinary proceedings make it to trial?
Oh, that's a good question. And I would have to, I don't know that I know the exact number, but if we take 100 to 170 cases, I'd say 7 cases a year, maybe formal complaints that actually go, I'm talking about discipline only, that go to a hearing. And those hearings are usually 1 to 3 days long. So it's a fraction of what is formally charged.
And John Banishek, I'm just going to reply to your question. Feel free to ask questions verbally at this point.
Your Honor, I have a question sort of about an opposite cold tap issue. I know that there are disciplinary proceedings based on people not taking money out of their cold tap account quickly enough. because of problems it could create for a client. And my question is, how quickly do you need to turn those over? For instance, if you have a settlement, a check, or if someone makes a payment on an account that that may have AR, but there's also additional retainer in that in the check that they're writing. What's the turnover time that would be acceptable? Every 2 weeks, once a month?
Let me see if I understand it. So you've got money that's supposed to go to a vendor or a client or that's in the COLTAF account, and it sits in there for a little while?
No, the opposite. It's money that's due to the firm. It actually should be transferred to the firm's operating account. And how quickly do you need to make those transfers?
You know, I've never had a case that came up with that issue where a lawyer was grieved, so to speak, for not transferring it to the firm quickly enough. Well, I guess I would just be speculating. I don't know. I haven't seen that case. But it makes sense to me that those transactions should be, you should take those actions as soon as possible. And the most important thing is to have communication with the client and let the client know where the money is going.
Thank you.
Sure.
Another question submitted via chat from Carolyn. What percentage of complaints come from opposing counsel? And also, as a follow-up, what's the standard for making complaints?
I think I can't give you a percentage, but if I remember, the Office of Attorney Regulation has an annual report, and they have those statistics. Do you recall what they said, John or Chris?
That I'm seeing if I can find that presentation. It should be fresh on my mind, given that it was yesterday, but I don't have the numbers off the top of my head.
It seems to me that there was a substantial number of complaints that do come from opposing counsel, and here's another area where the Office of Attorney Regulation, I'm pretty sure they use good judgment and discretion, because let's face it, ours is an adversary system, and lawyers do get crosswise with each other. And there's a difference between a complaint based upon personality or some other issue as opposed to a true rule violation. But I've seen a number of cases where the complaint comes from opposing counsel. And this is probably a good place to talk a little bit. I intended to do it and forgot, is about professionalism. I can't tell you how, from my perspective, I think that professionalism amongst lawyers is more important today than it ever has been. And I think lawyers have to set the example for how public officials and people who are respected or should be respected act in a proceeding, even if they're advocates. But many times what happens, and here's something that's not exactly on point with your question, but what I have seen in our courtroom is a lawyer will try to be civil and do the right thing, and the other side just keeps doing what they're doing, and they're not being civil and they're not being professional. And then there comes a point at which the lawyer who's on the short end of the stick decides, enough of that, I'm going to retaliate. And away we go. I call it a spitting contest. And no one comes out looking good in those situations. So I don't know what the percentage is. Chris, were you able to find that statistic?
I think I'm reading the statistic right, but it looks like based on the number of intake inquiries, so not actual formal complaints, but 18% of intake inquiries are logged by opposing counsel, or I guess submitted by opposing counsel. I think that's from 2019, and that looks like that's out of about 3,400 matters, requests for investigation that were filed in 2019.
Thanks. That was, I was guessing it was pretty rare that that the majority of the complaints were going to be from clients and not from opposing counsel. But that's helpful.
And that number could be, I could be misreading this chart. There's a couple of ways what I'm looking at could be read. I do want to direct people to Karen's comment in the chat room about statistical information being available on OARC's website. That's not what I'm looking at now, so that would probably be the better source to reference.
And let me add something here. One of the things that I've noticed in the cases over the years is that how important communication is, and communication with the court, communication with your client, communication with opposing counsel, and that it be civil. But a lot of problems with clients start with a lack of communication, and the clients start to wonder, what's my lawyer doing? I'm paying them and they're not answering my questions. And I know some clients, and we see this in the cases that we hear, can be very difficult. They want an answer every day, and there's got to be some reasonable amount of communication, and you don't need to go beyond it. But when lawyers don't communicate and just shut it off, that often leads to complaints.
Looks like that's all we had queued up for questions on the chat room.
Well, I've enjoyed this. I hope next time I do it, I can go to Boulder and have a glass of wine with you guys.
No problem. We'll be happy to host you. And then to all the attendees, thank you again for joining us. And I'll be sending out the CLE form here shortly, or first thing in the morning if it bounces back. But thank you very much to Judge Lucero for presenting tonight.
Well, you're welcome. I enjoyed it.
Excellent. Thank you,
Thank
everyone.
you.
Have a wonderful evening.
Good night, everyone.
Thanks, Chris.
You're welcome, Judge.